Thank you. Good evening, everybody. My name is Brian. I have the fortune of working full-time on campaigns to save historic places, and I have the opportunity to specialize in an area of law that not a lot of attorneys do, which is the federal laws and state laws that protect our historic resources. The National Trust, as was mentioned, was chartered, and part of our charter is to facilitate public participation in the preservation of America's historic resources. One of the really key laws that helps us all do that is the National Historic Preservation Act, which applies to federal agencies whenever federal funding or federal decision-making is involved with respect to projects that have the potential to affect historic properties. I'm just going to back up a little bit and talk about the broader context, and Tony's going to get into some of the finer details of the lawsuit and the latest. But I kind of want to explain to you all how the trust came to get involved in this, and you know, really what a privilege it is to be part of this community of people who is, I think Gray rightly said, is really the epicenter of resistance to this this program to dispose of historic properties nationwide. And the case we're involved in right now, I truly think is a test case for a lot of other potential disposals that could or could not happen based on what happens here. So it's really, I feel really fortunate to be a part of this and to work with all of you. Backing up, I really do think this problem is kind of a new one. In 1998, I found a quote in the Federal Register from the Postal Service that was very eloquent. Throughout the towns and villages of America, people have long viewed their post office as much more than a place to send and receive mail. A community's post office is a vital part of its infrastructure, a place to greet old friends, make new ones, and exchange information. With more than 35,000 leased or owned postal facilities, the Postal Service takes seriously its commitment to be a good neighbor and a vital part of every community. And this was only 15, 20 years ago that this was saying. So fast forward to the present, maybe 2010, 2011, really considerable momentum. You know, disposals had been happening. It's not as if they hadn't happened during the time when the 1971 charter for the new Postal Service up till now, but the rate just totally spiked right around 2010, 2011. And you know, on a broad national level, as we kind of look at this and our 11 most listing, you know, the concern isn't just one or two here and there, but when you have a program that's clearly being enacted where disposals are becoming just commonplace, you know, what happens to the future stewardship of the buildings? And the concern of ours really was that there was a very apparent lack of coordination. One process in one town could be totally different from one in another. And, you know, that has real impacts. I don't know if any of you have been to Ukiah recently and seen the downtown, but the sale of that of the post office building there, which is really in the historic part of downtown, has had a major impact on the small businesses. It's still vacant as far as I know, and that impacts the success of businesses which rely on the presence of its operation as they try to compete against the big box stores that are being developed on the outskirts. So, you know, I talked about the lack of internal coordination. Our campaign is really focused on trying to achieve a process where we can go from one community to the next and tell them that this is what you need to do, this is how you're to work with the Postal Service when you're faced with these facts, that they've made the decision that they're going to sell it. And really important to that, we've taken a very strong position on the application of the National Historic Preservation Act. The idea is that the Postal Service, before it makes a decision on a project that has the potential to impact historic properties, it has to consult with the public. It has to do so early. That didn't happen in Berkeley. It hasn't happened in many of the projects we've been involved in. And even more concerning is that the agency is going to really unprecedented lengths to disagree about the nature of the impacts that are caused when they move out of a facility. We were told in the fall of 2012, when we first wrote a letter to the Postal Service, that they needed to comply with the Act, that our analysis of the law was incorrect. So needless to say, that letter is now part of the record that we're using in litigation, and we want the judge to see that, and we want to have a decision that either says you're right, which would be kind of shocking to us, but more likely, we think, is that, you know, our view of the law, that early consultation is required, will be upheld. You know, I want to say, relative to this idea, that I think this disposal program is rather new, and I really, truly do hope it can change. But it seems to be directed, as I think you all know, from really high-level staff. It's not the typical employees that we interact with on a day-to-day basis. People at the high level don't seem to value the dignity that historic buildings are providing their employees, their customers, and most importantly, their reputation as an institution. Venice is one of the most startling places I've seen when you compare what's been built against the old. It's really an industrial warehouse next to a really glorious New Deal building that's now been privatized and doesn't have much public access. Before Tony gets started, I just want to introduce one of the tools that we've been using in the National Preservation Act process that's really critical, because it's a really point of our leverage in those cases. I don't know if the use of covenants. I don't know if any of you saw the article in Monticello in the New York Times maybe a week ago, but there was a byline that really caught my eye. It talked about how Monticello, after Jefferson died, was bought by a private owner who kind of didn't care for it. And it used the term the vagaries of the private marketplace. And I think that that's a really good analysis here. It's like, we don't know what happens in the private market. We have our government, theoretically, should be accountable to us. So what can we do to make sure that future owners of a property are worthy of it? And a covenant is one way to do that. And the terms, a covenant works, you attach it to a deed and it places restrictions on the property. The Postal Service has argued for a very watered down version of this, one that really doesn't require much on the owner. They were very reluctant to put in any terms that had much meaning, such as a lease back. You know, the idea is that a future owner would have to comply with the terms, and if they don't comply, then the public would have the right to bring an enforcement action against them. So they, you know, you could put in a clause where you provide public access. Some public process would have to take place so the private marketplace doesn't sacrifice our heritage to protect its profit. I think that our requests in the process that was followed were fairly reasonable. We were looking at a very watered down covenant that had no prospect for funding for a qualified preservation organization to look after this in perpetuity. And what ended up happening before our lawsuit was filed, which really I think gave us a good place to start with the court, is that the Postal Service took an action that just seemed extremely arbitrary. In order to just get done with the process, it volunteered that it would take on the compliance responsibility, enforcement responsibilities, which, you know, we were all kind of really shocked by that. That's not what we expected. So, you know, I think that to sum this all up, I mean, that there's really a demonstration here that the agency is not accountable to the legal requirements that are out there, and we're just really excited to hopefully move into another stage of the lawsuit, and which we'll talk a little bit more about. We're kind of dealing with some procedural issues that hopefully will be resolved this spring. and then we'll move on to a case on the merits this fall. So Tony,